Already? Okay. The Senate Judiciary Committee will come to order. The clerk will call the roll. Yeah, clerk will call the roll. Yeah, go ahead. You can't. We have a couple more people coming. Just wait till they get in here.
You got it, Mr. Chair. Is your microphone on?
Yeah. Yeah. Go ahead. Let Senator Stewart and Senator Deeds plug in.
Three. Vote.
Senator Stewart also.
Mr. Chair, you do have a quorum.
Okay, thank you. We do have a quorum. All right, thank you all for being here. First of all, Senate Bill 199 of Senator Mason's. I've been asked to have that re-referred to the Committee on General Laws. This is a bill that deals with public auctions of personal property to satisfy liens. Is there a motion? Okay, it's been moved and Senator Deeds seconds it. To re-refer Senate Bill 199 of Senator Mason's to the Committee on General Laws. All in favor of the motion, vote aye. All opposed, vote no. Just vote aye, okay. Okay,
Ayes 13, no 0.
motion passes. Senator Mason's Senate Bill 199 has been re-referred to the Committee on General Laws. Okay, the next bill is Senator Ruff's. Is Senate Bill 63, Abuse and Neglect of Children, Safe Haven Defense. Is there, Senator Ruff, nice, welcome.
Senator Bill.
Mr. Chair.
Yes,
Mr.
Senator
Chair.
Peake, Senator Peake.
And I have a bill that is very similar. I add newborn safety device, my Senate Bill 175. I suspect
Mr. Chairman, I'd be delighted to roll my bill into Senator Peake.
that mine should roll into Senator Ruff's bill.
One of them's got to be rolled into the other, but they both can't be rolled into each other.
Charles,
Is there a motion?
is that, is council's, mine mentions a newborn safety device, but I still think we're both going from 14 to 30 and could combine the two.
Yeah, Mr. Chair, that's correct. Senator Peake's bill does have additional language regarding the newborn safety devices, but they are similar bills, and they both increase the time from 14 to 30 days.
Senator Ruff, will you please have my bill?
Okay, so we're saying that Senator Peake's bill 175 is to be rolled into Senator Ruff's bill, Senate Bill 63. Is that the motion, Senator Peake?
That's my motion.
Okay, is there a second? All right. All in favor of the motion that Senate Bill 175, Senator Peake's bill, be rolled into Senate Bill 63 of Senator Ruff's. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 13, no 0.
Motion carries. Okay, who wants to present it? Senator Ruff?
Mr. Chairman, Senate Bill 63 simply extends the length of time that a mother of a newborn can turn that over to a hospital or other medical facility when she does not believe that she can physically or mentally take care of the child.
Okay.
It doesn't change any of the rest of the law.
Mr. Chair,
Yeah, Senator Peterson.
where is the actual change? I've got a 10-page bill here, and I'm looking for the text that actually is being changed.
242.
342?
Line 242.
Mr. Chairman, it's on multiple lines.
Where?
The first change is on line 54, changes from 14 to 30 days.
Oh, I see, okay.
The second change is on line 262, 14 to 30 days, 280.
Okay.
Okay, it's throughout the sections. Anytime there was a reference to 14 days, it was changed to 30 days.
Mr. Chairman.
Yeah, Senator D.
Senator Ruff, what's the reason for the change?
A request from a constituent.
Is there some policy?
This was a bill you put in last year, isn't it?
We talked about it, but I don't think I actually did it, but I may have.
Okay.
Any questions about the bill? It changes from 14 days to 30 days, the maximum age of an infant from a parent who voluntarily delivers the child to the hospital, emergency, or emergency medical services.
And Mr. Chairman,
Yeah. And claims the affirmative defense. Yeah, Senator Peake.
and similarly, I believe it happened, there was someone in our general area at one of the hospitals where someone instead of within 2 weeks, within a month, attempted to follow the statute, and that's why the request. And I think, in the part of my bill that adds the safety device, some of the hospitals are now putting in certain delivery areas where someone can anonymously drop off a baby to protect the baby within the 30 days. So
All the hospitals don't have to have the safety device, though, right?
it's not required. No, it's not requiring it. But if they have it, they can be used in up to 30.
Senator Boysko? Yeah, okay. Any questions of the patrons? Plural patrons?
Mr. Chair, just a clarification.
yeah,
So we are
Charles.
using Senator Peake's language in Senator Ruff's bill. Is that my understanding?
Well, we keep them separate.
Or the two bills?
Safety device is the only.
So Senator Peake's bill has a safety device that hospitals can have, but not all have them.
Mr. Chairman, that's why we left that part of the bill out. The request was for that, but we did not believe that the medical world would be happy at this point with it. We'd rather see them do it voluntarily.
Well,
It's
do you want
mine.
to undo the rolling in?
Mr. Chairman,
Yeah, Kristen.
it's not required that they have the newborn safety device. The bill, Senator Peake's bill just says if they do have it, it needs to meet certain standards, which are outlined in his bill. So it's not requiring them to have it.
Okay, all right. Everybody understand that? The bill has been rolled together, okay? Any discussion? Any questions of the patron? Anybody in the audience would like to say anything about the bill one way or the other? Been moved by Senator Norman.
Your pencil, Sean.
And seconded by Senator Peake that the rolled-in bill, which is now Senate Bill 63, pass. All in favor of the motion, vote aye. Aye. All opposed, no.
Ayes 12, no 0.
Thank you, Mr. Chairman.
Yeah, thank you, Senator Ruff. Okay. All right, moving on, Senator Hanger and Senator Obenshain have similar bills. Huh?
Mr. Chair, we're waiting on the clerk of the Senate to advise me that Senator Obenshain is allowed to participate this morning.
Yeah, Senator Obenshain called me yesterday. He would like to have his bills. He's going to be here remotely. He's not well, and he won't be here till Wednesday, he thinks.
Understood.
And he's requested his bills and Hanger's, he has similar bills with Senator Hanger, be put off till Wednesday.
Mr. Chair, I'm bringing him into the Zoom room.
Okay.
Oh, sorry. We're passing them by. Okay, understood.
Yeah, we can pass it by till Wednesday.
Thank you, Chair.
Yeah, okay. Senator Obenshain, are you there on remotely?
Mr. Chair, he is now.
He is not.
He is now.
He is now, okay. He is now, okay. Senator Bill.
I'm here. Thank you, Mr.
Yeah,
Chairman.
Obenshain, okay. Go ahead.
Mr. Chairman, I think you're going to pass those bills by till Wednesday. I will be there on Wednesday.
Okay. All right. Without objection, I think we can do this. Senate Bill 1, and Senator Obenshain, make sure I'm doing it correctly. Senate Bill 155 of Senator Hangers is going to be gone by until Wednesday. What's the next ones?
122 is mine.
122, which is, what the heck is this?
Mr. Chair, Senate Bill 122, Senate Bill 227, and Senate Bill 228 are Senator Obenshain's bills on the docket.
Okay. Along with Senator Hangers, 155. Is that correct?
That's correct,
correct.
Mr. Chair.
Okay, let me do it again. Senate Bill 155, Senate Bill 122, Senate Bill 227, and Senate Bill 228 are going to be put off, go by for the day and bring back on Wednesday. Is that correct? Okay.
That's correct.
Without
Thank you.
objection, it'll be so ordered, without objection. Okay? The next bill then is Senator Evans' bill. Senator Evans' bill, supplementing compensation of public schools. You're not here, okay.
This is,
Yeah. I'm sorry.
actually about public defenders.
Okay, I'm sorry. Supplementing compensation for public defenders. Yeah, Senator Evans.
Thank you.
Welcome.
Thank you, Mr. Chairman. The bill requires that the government of any county or city that elects to supplement the compensation of the salary for the Commonwealth Attorney or their deputies or employees must proportionally supplement the compensation of the public defender. And it's proportional if the public defender, their deputies, or local employees are each paid amounts commensurate to the closest equivalent experience in the local Commonwealth Attorney's office. And the additional compensation would wholly be paid from the funds of any city or county. It also allows a locality to supplement the compensation of the public defender or any of his deputies or employees using another formula that's agreed to by the public defender in the locality. We know that there's a dramatic need for public defense, and that despite that, our state public defender officers are dramatically under-resourced and understaffed in comparison to our state prosecutor offices that create an imbalance undermining fair trials. In Virginia, though the base pay for the public defenders and Commonwealth attorneys is often comparable, it's a common practice for local governments to allocate additional funds for Commonwealth's attorneys and not to public defenders. This can result in a significant pay and resource gap. In some jurisdiction, the pay disparity is 40 to 50% per position, meaning prosecutors can be paid almost double that of their counterparts on the other side of the courtroom. Additionally, lower salary levels of public defenders creates an employment issue. Turnover is high, and the ability to attract talented attorneys, many of whom have exorbitant debt from law school, is challenging. And I should just add just a few more points that in many offices, there's also an experience gap due to turnover. And because public defenders are paid so much less than Commonwealth attorneys, they're less likely to have attorneys with extensive experience in the office. Commonwealth attorneys can afford to make a career out of their positions and therefore tend to stay longer, often decades. It's not uncommon for a prosecutor with 10, 20 years of experience to go up against a public defender just a few years out of law school. This tips the scales of justice in favor of the prosecution. Turnover drops significantly in offices with supplements. Salary supplements allows public defenders to make a career just as Commonwealth attorneys already do in jurisdictions that have supplements. And the stat I'll give you last is that because this is not required by law, only 9 of the 28 public defender offices in the Commonwealth receive local subsidies. And I do have a few witnesses.
This, of course, has to go to finance, but this only applies to public defender offices, not to court-appointed attorneys, which is a different
correct,
situation. Okay. All right. Yeah. Have somebody to speak?
I have at least 2, I believe.
Okay. Good. Thanks. Welcome.
Good morning, Chairman Edwards, members of the committee, Maria Jankowski with the Virginia Indigent Defense Commission. I'm not going to repeat everything that Senator Evans said, all of which is correct. What I'll add to it is 2 things. Public defenders in Virginia are below what we've found to be, to the extent that you can find a national average. Our starting salary for a public defender is approximately $56,000. And that's
$56,000.
with student loan debt. And the other point that I want to make that may get lost in this is the disparity between public defenders and Commonwealth attorneys is caused by the localities. And that's why we don't come back to y'all and say, if every time the locality kept raising the pay for the prosecutor, we had to come to y'all and say, need to give us more money. We don't do that. We go to the locality and we say, hey, you've now poured all this money into the Commonwealth Attorney's Office. Can you at least give us some parity? And to be clear, this is not parity with the overall supplementing of the Commonwealth Attorney's Office. Localities are free to fund positions, initiatives, support staff. This is simply parity with the salary supplements that go on top of what the Comp Board state supplements. Thank you very much.
Thank you. Yes, Senator Morrissey.
Ms. Jankowski?
I'm sorry.
Is it true that where there is a Commonwealth Attorney's Office and a Public Defender's Office in the same locality,
Yes.
take Chesterfield because we just added one,
Right.
that the number of prosecutors in the PD's office are often less or always less than the number of prosecutors in the Commonwealth Attorney's Office?
Senator Morrissey, members of the committee, by and large, the answer is yes. When I have been asked by the General Assembly to model out staffing for public defenders' offices, the single largest wild card is staffing in the Commonwealth Attorney's Office. That varies widely across the Commonwealth. So I have never found a jurisdiction where they would be smaller, but the difference can range widely.
Mr. Chairman, in those situations where you have a PD office and a Commonwealth Attorney's Office in the same jurisdiction, by and large, the salaries set by the State Compensation Board are less for the PDs than the CAs because the CAs often have more years of experience. Would you agree?
Senator Morrissey, members of the committee, the Comp Board doesn't set our staff salaries. We're not under the Comp Board.
Okay. Final question.
Yeah, Senator Morrissey.
Is the gist of this bill that if a locality provides, say, $200,000 in additional supplemental pay for the, say, Richmond Commonwealth Attorney's Office, then $200,000 in additional pay will be allotted to the PD office in Richmond?
Senator Morrissey, members of the committee, not really. And I think the beauty of this bill is it's a proportionality analysis. And what Senator Eben has put into this bill, it actually gives the local public defender and the locality the ability to come to another formula that makes sense. In some jurisdictions, it's just been simpler for the locality to do 15% on top of our salaries. So it gives the locality and the public defender some flexibility to come to a workable solution.
Okay, Senator Stewart.
Maria?
Yes, sir.
I'm just curious. I appreciate what he's trying to do. I don't think this is the right way to do it, and there are a bunch of reasons why, which I'll spare you all. But in fact, couldn't the localities already do this?
Senator Stewart, yes, sir.
Thank you.
Yeah, Mr. Chair.
Yeah, Senator Peterson.
I'd ask Maria, what about the fact that Commonwealth's attorney is an elected position and his deputies are just that, they're political appointees? I mean, they're constitutional officers as opposed to the public defenders are employees of the county. So they're kind of reporting to different masters, so to speak. Does that affect this analysis at all?
Senator Peterson, that's a good point. What I would say is kind of. The Commonwealth attorneys beyond the elected Commonwealth attorney are kind of funded hybridly. So there are jurisdictions where I believe the locality, based on resources, probably isn't significantly supplementing even their Commonwealth attorney office. But in the areas where they are, where they're taking the comp board salary and then adding to it. Those areas the locality is what is causing the disparity. And so the solution is, instead of me coming to you and saying, Fairfax now has poured $4 million into the Commonwealth Attorney, you need to give me $4 million or $2 million or $500,000. This would just say to Fairfax, in your analysis of how much more you're going to pad their salaries, you need to take that into the equation. And in many instances, it's pennies on the dollar.
Mr. Chairman.
Yeah, Senator Peterson. Who has?
Over here.
Oh, okay, Senator McDougal.
Maria, as we're talking about this, only the Commonwealth's attorney can bring prosecution in these jurisdictions, but in areas where there are public defenders, there are private attorneys that can be retained. And in addition, if there are conflicts, there are also court-appointed attorneys that work in those jurisdictions in addition to the public defender's offices, correct?
Senator Majulu, yes, that's absolutely correct.
So if we're looking at staffing numbers, you wouldn't expect there to be exactly the same because there are a numbers of matters that are being handled by private attorneys or court-appointed attorneys, not the public defender's offices.
Senator McDougal, that's absolutely correct.
Okay.
That's why this is about salaries, not staffing.
Yeah. Can I just,
Yeah, Senator
Mr. Chairman, just briefly on Senator McDougal's point, this is about funding positions, not funding the office. If you gave about people having commensurate experience getting similar supplements, it's not about if you give the Commonwealth's Attorney's Office $2 million for some reason that you would have to give the public defender that exact same amount. It has to do with commensurate experience and positions.
Okay. Any other questions? Okay. Anybody speak against? Here, go ahead.
Good morning, Mr. Chairman. Michael McMillan here on behalf of Justice Forward Virginia. I'm here to speak in favor of this bill. Members of the committee, the Constitution guarantees that everyone that walks into a Virginia courtroom as a criminal defendant gets effective, zealous representation, and that is publicly funded. We fund both the prosecution of a criminal case as well as the defense of a criminal case. But beyond just walking into the courtroom, representing their clients, reviewing discovery, those sorts of things that we normally think of in litigation, public defenders also take on a number of different roles, such as social worker and things like that. They help their clients find substance abuse treatment. They help their clients find mental health treatment. They help their clients who are experiencing homelessness find stable housing. And we have a situation in which on each side of the equation where there are similarly educated, qualified, and talented attorneys, as the senator said, there can be upwards of a 50% difference in terms of their pay. This leads to a problem of attrition in public defender offices at the very time when young attorneys are trying to buy houses, start families, that sort of thing. People are leaving these offices. These are state-funded offices. We want these offices to be filled with employees who are there gaining experience, gaining a career, and serving the Commonwealth well. If there is this constant problem with retention and a rotating cast of young lawyers going through the system, those offices are not served well. We have an adversarial series of justice in our Commonwealth, just like we do everywhere else in the country. We often think of this with the scales of justice. The way that the pay works in Virginia and a lot of places is that one side of those scales of justice is being paid a lot more than the other side. The system works when all sides are at their best. This bill helps accomplish that, and we urge you to support it.
Okay, any questions? And I understand this is a delayed effective date to July 1, 2024, is that correct?
Yes,
okay.
sir.
Yeah, go ahead. Next.
Thank you, Mr. Chair. I'm Phyllis Arrico with the Virginia Association of Counties. While we agree that there's an issue, we oppose the solution. I think it's important to understand that constitutional officers are paid through the Comp Board and public defenders are state employees paid by the Indigent Defense Commission. Neither of them are local employees, and localities have no say in their pay scales, their evaluation, their raises, and things like that. We oppose this bill. We think this is the wrong solution, even though there is an issue. And in 2020, when Delegate Bourne brought this bill, we did send out a local fiscal impact. And just to give you an idea, the ranges of the fiscal impact for localities were from 120,000 to 1.5 million. And if this bill were to pass, in all likelihood, localities would not have the funding and would end up having to withdraw their supplements for the Commonwealth's attorney. So therefore, we oppose this bill. Thank you.
Okay. Any questions? Yeah, Senator Borsko.
Thank you, Mr. Chair. Senator Evan, I would just like a little clarification because I thought you were saying that the Commonwealth would be providing the supplemental.
No, the Commonwealth pays the base pay for the, this is if a locality chooses of their own volition to supplement the prosecutor's office, that they would also do commensurate with the position and the experience for the public defender office. So there would be no cost to the state. The reason I put a delayed enactment date was just so that the localities would have time to phase into this. It's not my goal to stop them from supplementing what they're doing now, just a few years to get ready.
Thank you so much.
It's got to go to finance too. Okay, next, any questions? All right, next speaker.
Good morning, Mr. Chair and members of the committee. My name is Ashley Shapiro, and I'm a deputy public defender here in the city of Richmond. I just wanted to put a bit of perspective on what these numbers actually look like in a jurisdiction. I've been heading our committee here in the city to try to get our public defenders in Richmond compensation. We were marginally successful last year and got half of our ask, but I will let this committee know it looks very much like we are going to lose that funding this year. It does not look like the mayor is going to put us back in the budget, and we will have to fight that budget fight again in city council. What those numbers look like. In Richmond, the Commonwealth's Attorney's Office gets over $8 million in funding. About 1.2 of that is just in salary compensation. So those positions are funded at the state level. They get an additional $1.2 million just in salary supplements. Compared to, as of before last year, the Public Defender's Office got zero. We are still working on that campaign. We are hopeful for this year, but without some intervention at the state level to make sure that those at least come close to being even, we are at a significant disadvantage. I will let you know, even in our offices that do have supplements, such as our Fairfax County office, their local government is trying to take those away, lessen those. It's a constant battle every single year to just keep those scales, even for the offices that do have them. What this bill would do would actually make sure that if a jurisdiction chooses to put their funding in the Commonwealth's office, they then must also fund the other side of the aisle. Thank you.
Okay, any questions? Okay, thank you. Is there anybody else who'd like to speak one way or the other on the bill?
Mr. Chair, we do have some speakers who have signed up online.
Okay, online. Go ahead.
Genevieve Miller, please unmute and begin your testimony. Norman Eichen, you will be next.
Good morning, Senators, and thank you so much for the opportunity to speak. My name is Genevieve Miller. I'm the Deputy Public Defender at the Prince William County Public Defender's Office. We are an office that does have current supplement from our locality, and I speak to the Senate today in strong support of the Senator's bill for all localities to equally fund public defenders' offices. My colleagues, Ms. Jankowski and Ms. Shapiro, have touched on a lot of the same points I wish to raise, but I did want to bring to the Senate's attention my own personal experience with the exact problem that underpaid, underfunded public defenders' offices leads to attrition of young attorneys, as I myself was a young attorney that had to leave my former posting at a public defender's office due to the lack of salary being able to afford student loans and the high cost of living in Northern Virginia. I was lucky enough to be able to return to a public defender's office at a higher rate of salary, but that's not the case for so many of my colleagues who have had to leave a profession that they're very passionate about with regards to public defense for higher paying private bar options. This would help to equalize the disparity between pay in commonwealths and public defenders and help to retain talented young attorneys to balance the defense side of the equation in prosecutions. Thank you for the Senate's time.
Any questions? Okay, thanks. Next.
Norman Eichen, please unmute and begin your testimony.
Good morning, Senators of the committee. I can't add very much more to what everyone has said before, and I won't reiterate. I'll simply summarize one particular point. The Commonwealth already has all the cards, practically. The Commonwealth's Attorney Office is extraordinarily resourceful and powerful, even compared to district attorneys across the country. So not only with that fact in mind, many of the bills that are out there right now, the 1,300 plus bills, are about rolling back and creating more inequities. This is an opportunity to level the playing field and allow the common person like myself to be able to fight. Had I not had several wealthy people who were in my corner, who are able to afford excellent representation, I would not have been able to fight the charges as well as I did. So this is very, very important that people who have fewer resources or are not as lucky as me have absolutely everything they need. And in counties that really don't have much, they need that supplement. And I would urge the committee to do whatever it has to, refer it to appropriations or wherever, to make sure that money is available to support local communities. Thank you.
Can you state your name again and your position? I'm not sure I got that.
Norman Michael Asian. I'm acting in my personal capacity as a Virginian.
Okay. Any questions of the witness? Okay. Any other witnesses? No witnesses. All right. Any further discussion of the bill?
Move to report.
It's been moved. I'm sorry.
Chair, this does need to be sent to finance.
It's been moved and to report and re-refer to finance.
Mr. Chair.
Yes, Senator Peterson.
Yeah, I'm very sympathetic to this bill and to the public defender's office. I just think practically this is going to be impossible to implement. Like I said before, Commonwealth's attorney is a constitutional officer. They have to run for re-election. Their deputies are just that, deputies. They're at-will employees. Public defenders are different. They're state employees. They're not paid through the comp board. And it's also, they're in a lot of ways apples and oranges, and the comment was made, a lot of criminal defense is handled by private attorneys or by court-appointed attorneys. It's very hard to just sort of compare them. And I'll say, my colleague even says, he talks about in his bill on line 26, a quote, another formula agreed to by the public defender in the locality. Well, what's that formula gonna be? It's almost like it's gonna have to be an agreement to agree. And this is a feel-good bill. Okay, I get that, and we want to say we support public defenders, but we're not spending a nickel, folks. This is the classic example of an unfunded mandate, so I can't support the bill.
Yes, Senator Morrissey.
I've got great respect for my colleague from Fairfax City, but notwithstanding his comments about the Commonwealth Attorney's Office being a constitutional officer and his staff also being constitutional officers, we're talking about a supplement from the local municipality that goes to that Commonwealth Attorney's Office. If the city or the municipality decides to make that supplement, all this bill does is that there is a proportional supplement to the PD's office. Accordingly, the fact that the CA is a constitutional office, I think, is a non-starter. It doesn't affect anything that the patron is trying to do with this bill. I hope that the panel will support it.
Okay, Senator Norman.
Thank you, Mr. Chairman. I associate myself with the comments made by Senator Peterson to impose this mandate on local government where there is a distinction between the employer of the Commonwealth Attorney's Office and the Public Defender's Office. This is not a good approach.
Okay. Any other comments from anybody? All right, we have a bill before us. It's been moved. And who seconded it? Yeah, moved and seconded that the bill be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, vote no.
Senator Obenshain, how do you vote?
Obenshain votes no.
Ayes 8, noes 7.
As 8-7, the bill is reported and re-referred to finance.
Thank you, Mr. Chairman. I do have one other bill, SB 389.
Okay, Senate Bill 389, I think this should be short. You
I
want
hope
to
so.
repeal something, all right?
Yeah, I want to repeal a code section 20-88 from the 1950s, which requires that those of sufficient earning capacity or income assist in providing for their mother or father when they are in necessitous circumstances. Currently, those who do not support a parent can face a fine of $500 or up to a year in prison. The statute is rarely used, it's outdated, and it was written before Medicaid, Medicare, Social Security, and hospital-specific financial assistance. Most states that have filial responsibility laws don't enforce them. And of course, when this was first enacted in 1920, it was more common for families to live in close proximity and depend on one another for care. There was a great law review article, which I won't read to you, which I sent to a few of you last night from the University of Richmond Law Review, about how this derives from trying to not have the Crown's treasury depleted by people when their families could take care of them. It's unclear whether it applies to children residing in other states, even if those states don't have similar laws, as to who qualifies for the vague language, which causes some constitutional questions. And I'll give you just 3 examples. A brother who had run his mother's finances into the ground sued his sister to hold her liable for his financial mistakes, burdening her with substantial litigation fees. The law provided a forum for a stepfather to retaliate against his wife's children after the children petitioned the court to replace him as their mother's guardian. A man was permitted to sue his less solvent brother to contribute a greater portion of their parents' luxury assisted living facility bill. It cleans up the code by removing outdated and underused statute that is open to abuse in modern day. Several states have recently repealed similar laws, including Iowa, New Hampshire, Idaho, and Maryland. 26 other states have similar statutes, down from 45 states in the 1950s.
Okay, any questions of the patron? Everybody understand this outdated bill? It's rarely used. Is there any questions? All right, this motion, is anybody who wants to speak one way or the other? Okay. All right, Senator Norman moves to report the bill. Senator Saslaw seconds it. Are you seconding it, Senator Saslaw? Okay, any discussion?
You need to vote against this.
All in favor of the bill, vote aye. All opposed, no.
Senator Obenshain, how do you vote?
Obenshain votes aye.
I thank Senator Deeds for letting me explain this further.
Okay, thank you, Senator.
Thank you.
Evan, thank you very much. Now, Senator McPike, you were here earlier. I didn't.
Mr. Chairman.
Just a minute.
Mr. Chairman, I'm going to defer to this.
Can a clerk report Senator Lucas voting yes on the last bill?
Yes, I can, Mr. Chair. That would be ayes 14, noes 1.
Mr. Chair, I'm going to defer to the all-powerful local government committee chair. My bill's going to take a little bit longer than the 9 a.m. Time which he has to gavel in.
Okay.
Thank you, Mr.
All
Chairman.
right, Senator Lewis, do you have a simple bill?
Yeah, 2 simple bills, I hope.
Okay.
And thanks to Senator McPike for his courtesies.
Which bill are you promoting?
Senate Bill 497, which is about as parochial as you can get.
Okay. Bill 497.
Yep. Yes, sir, Mr. Chairman.
Judge, is that right?
Yep. Let me explain to you the situation on the ground here.
Has it been recommended by anybody, Mr. Chair?
No, well, I'm just saying.
Yeah, go ahead, Senator Lewis.
From time immemorial, this has been the status. And I talked to the chief judge this weekend, who was already aware that I was going to do this, Chief Judge of the Second Circuit, and he said, we just always assumed it would be that way. But times change, people move on, memories fade. So we thought perhaps it would be best to put this as a Section 1 bill so that everybody knows that the policy reasons it has been that way for 50-plus years are valid and need to be memorialized. So that would be it, Mr. Chairman.
Okay, this is not a new judge.
No, no.
It just simply says that one judge in the Second Judicial Circuit should be a resident of the county of Accomack or Northampton.
And actually, Mr. Chairman, I've got a small, I've been cautioned that there can be some creative mischief with resident, and that I should also put and domiciliary in there.
And
so I would offer that amendment.
Is there a motion? All right. All in favor of the amendment, say aye. Aye. All opposed, no. Okay, you want some judges to move in your area?
Mr. Chairman, I have a quick question.
Yeah, Senator Shervill.
The way it's worded, it doesn't seem to delineate whether it's a circuit, general district, or juvenile court judge. Is that the intent? Is to any judge?
Actually, I think it is correct because there is a subset of the Second Judicial Circuit for J&DR and General District 2A, which are specific to Accomack and Northampton counties. So I think that reference would only apply to circuit courts.
Okay, if that's your
Yeah.
intent. You think that's how it works, it's fine.
Senator, usually the judges in the area among themselves decide where they're going to sit. They don't do that there?
No, and this judge, who is typically from those two counties, actually does sit in Virginia Beach when he's needed. Yeah.
All right, section 1 bill. So nobody's going to know about it except the people who want the bill, right? Any discussion? It's been moved that the bill as amended be reported. All in favor vote aye, all opposed no.
Senator Obenshain, how do you vote?
Senator Obenshain votes aye.
And
Ayes 15, no 0.
Okay.
Thank you, Committee.
Senator Lewis, you got another bill, 198?
Yes, sir. Senate Bill 498, and let me inform the committee about what evil I'm trying to correct here. So I had a specific situation that came.
Oh, wait, did we finish that bill?
Yes.
Okay, yeah, okay, still up, all right.
This is 498,
Yeah,
Mr. Chairman.
Yes.
So I had a situation.
No, 498.
Had a situation where a deed was prepared, a closing was had on some de minimis valued property in Northampton County. The deed was recorded, accepted for recordation by the clerk's office, and then about 4 months later, I got a letter from a deputy assistant analyst in the Commissioner of Revenue's office who said they were not going to recognize the efficacy of the deed transferring title and were going to keep it in the former owner because there was not a senior after the name of the signatory on the deed. And I informed them, first of all, that nobody has senior on their birth certificate. And secondly, that it was not their place to make that determination absent a court order. And so what this bill seeks to do is to make clear that once a deed has been accepted by the clerk, the keeper of the land records for a county for recordation, that nobody else in any agency and I need to make an amendment on here, it should be government agency and offices, is to second guess that absent a court order. And I also, if you'll see the last sentence in there, makes clear that that presumption does not apply to any litigation that may be going on. It's particularly for those folks. This is my strike back at bureaucracy.
Yeah, where's the amendment again?
After agency, it should be and offices.
Agencies and offices. Are all in favor of the amendment to add the word and offices on line 14 after agency? Say aye. Aye. All opposed, no. Motion carries. Okay, you ready to go with the bill?
That's the bill, Mr. Chairman.
Okay, any discussion? Anybody want to speak in favor or against the bill? Is there a motion?
Move to report.
It's been moved and seconded that the bill as amended be reported. All in favor of the motion vote aye. All opposed, no.
Senator Obenshain, how do you vote?
Obenshain votes aye.
All right. Thank you, Mr. Chairman. Thank the committee.
Ayes 14, no 0.
Ayes 14, no 0. The motion carries. Senator McPike has been waiting patiently, we hope. He's got some bill that needs a substitute. Senate Bill 514, guardianship and conservatorship of incapacitated persons.
Thank you, Mr. Chair. I believe the substitute is before you for adoption and consideration.
Is there a motion? All in favor of the substitute being adopted, vote aye. Say aye. Aye. All opposed, no. Motion carries. All right, we got the substitute before us.
Thank you, Mr. Chairman. Senate Bill 514 is a result of several years of effort in regards to looking at potential improvements to the guardianship process in Virginia. I first wanted to take a moment to thank the JAILARC staff. They have put a considerable amount of work over the last year plus identifying current opportunities to improve our system. As you know, when we have a guardianship, this is one of the most vulnerable populations without current safeguards in terms of private guardianships. The good news is they found a fairly robust and a public system that works well. However, on the private side, there are many needed areas of improvement. Additionally, I wanted to thank the Office of Executive Secretary, staff, also the Virginia Elder Law Coalition, Virginia Poverty Law Center, and the American Bar Association Commission on Law and Aging, Erica Wood, and most importantly also one of my constituents, Yolanda Bell, who's been a tireless advocate over many, many years. Now, what the bill does in many different sections, first off, it takes up JLARC recommendations number 6, 10, 11, and 12, requiring the Office of Executive Secretary to maintain and update their training for circuit court judges on guardianship and conservatorship, and to improve information available on the qualifications of guardian ad litem available for guardianship cases. This is something that actually the judges identified as a need themselves, because these cases sometimes don't come up that frequently. Additionally, judges tend to use the same guardian ad litems over and over because they're not familiar with other GALs and create the appearance that guardian ad litems are rubber stamp petitioners for the courts. Additionally, this bill takes up to expand the Department of Aging and Rehabilitation Services responsibilities to include private guardianships recommendations number 17, 22, 23, 24, and 26 of the JLARC report. Most Virginians who are under the care of guardian have a private guardian, and a private guardian is not subject to any standards. No caseload standards, training, or requirements to visit the people under their care. In fact, JLARC found that 11 different private guardians cared for a total of more than 500 adults. Adults are not under guardianship by choice, and so there should be similar assurances of quality care between both public and private systems. The additional responsibilities for DARS includes developing training and providing it to all guardians on their responsibilities, developing training and providing it to the Department of Social Services on how effectively to evaluate guardianship situations, to develop a process to share reports of adult abuse and neglect filed against people who have been appointed to be a guardian and who are being considered for the role of guardian. Creating and administrating a process for receiving complaints against guardian, and it also crafts a proposal for how regular visits by state and local staff could be made to individuals who are under guardianship to make sure that they are receiving quality care. Additionally, the bill takes up JLARC's recommendation number 14 for periodic review hearings. It includes a review hearing 1 year after the appointment of a guardian, and then at least every 3 years thereafter. Guardianship is a lifetime appointment. The median age of an adult under guardianship in Virginia is 44, so the relationship can last for decades. The guardianship typically removes nearly all of an adult's rights to manage their affairs, giving the guardian authority to make decisions that can directly impact an adult's mental and physical health and relationships. Adults' conditions can change over time, which can reduce their need for guardianship. And at the time of the initial hearing to appoint a guardian, it's not always possible to assess with certainty the adult's likelihood of improvement. An initial guardianship appointment can be contested, and there's value in revisiting the initial decision to place the person under guardianship or to evaluate the guardian. Guardianship and conservatorship affect some of the state's vulnerable citizens, incapacitated and often indigent adults who often have little ability to seek recourse because of lack of resources to petition the court for change or not knowing how to do so. Other states' guardianships and other types of hearings in Virginia, such as civil commitment, have periodic reviews. Additionally, guardianship case count in terms of the overall caseload right now is just 0.6% of the total filings at the circuit court each year. JLARC has recommended that the proposed legislation try to mitigate the additional workload. For example, the new review starts after this legislation would be passed, and therefore it is from these cases moving forward. So the new caseload for the courts would basically be a rotation of every 3 years thereafter. The court system does have a process to waive those should they find it unnecessary. Additional recommendations from JLARC include recommendations 27, 29, and 30, creating and allowing a guardian to keep someone from visiting or contacting an adult under their care, and provides a process for notifying the person who is restricted for them and to seek recourse. Visitation and contact from family and friends is important for adults under guardianship, but restrictions can be necessary to protect the best interest of adults. JLARC found that guardians have too much authority to restrict who can visit, contact adults under guardianship. This is because the code does not define specific criteria or reasons to justify such a restriction. This bill sets out to make sure that it's articulated what that process looks like. So JLARC staff recommended that the criteria for improving a visitation be restricted be improved. This bill does that now. The new criteria makes it clear that the restriction is for protecting the health and well-being of the adult, and also to prevent the physical, mental, and emotional harm or financial exploitation that would generally align with other states that have laws to this effect. Additionally, this bill takes up recommendation 20, requiring that guardians visit the individual under their care at least once every 90 days and stipulates what the visit entail and document that visitation. Additionally, it takes up recommendations 18 and 19 from the JLARC report, requiring the Department of Aging and Rehabilitation Services to develop training for private guardians and require private guardians to take it. Additionally, it takes up recommendation 21, requiring the annual guardianship report. This is currently done under the public setting, but not the private, so it does provide the documentation of those visits and the care that's being provided to the individual. Mr. Chairman, this has been a long process, and I appreciate the stakeholders coming together to fine-tune the substitute before you. This has been a collaborative process for quite some time, and happy to address any questions from the committee and allow additional speakers who may also contribute to this discussion.
Senator McPike, I have a question. On lines 310 to 314, it says the guardians, including private guardians, must complete training within 4 months of the date for entry of initial order of appointment. And that's to be done by the Department of Aging and Rehabilitation Services? Is that realistic?
That is the training and the framework that's been discussed to provide a reasonable ramp-up time for the individual appointed to achieve that training.
And is that waivable?
What this bill sets out to do is to set both the training and then the time frame for those guardians to then achieve the training. So there's twofold that DARS.
Yeah, is that waivable? Waivable?
No.
Okay. So you say some guardians have like 500 wards they're dealing with?
Yes, Mr. Chairman.
Incredible. Okay. All right. Any questions of the speaker? Anybody would like to?
Mr. Chairman, I have a
Senator
question.
Sherwood.
Thank you, Mr. Chairman. Senator McPike, I'm glad that somebody looked at this issue comprehensively, and I remember there was some discussion over the last 2 or 3 years about concerns where hospitals were petitioning for guardians, and there was a concern about the fact the hospital was paying the fees of, I think, the guardian ad litem doing the investigation, I think it was. Is this, any of the recommendations deal with trying to tease out the potential conflict where the hospital is paying for the guardian who has to make recommendations about what the hospital should do? Or, I mean, I remember that when we looked at it, that problem was kind of intractable. We couldn't figure out a way to solve it. Did JLARC come up with anything? Is there anything you know about that?
There may be some speakers to that specific question. I believe that was teased out previously in terms of the conflicts, but there may be someone else here that can speak to that specific. I know what you're talking about in terms of hospital case and conflict of potential interest there.
Yeah. Okay. Any further questions of the patron? Okay. Anybody in favor of the bill? Please step forward.
Mr. Chairman, Colleen Miller from the Disability Law Center of Virginia. Good morning. Our thanks to the senator, and I just want to join his thanks to JLARC staff. This is really a very good, comprehensive bill, and we fully support it. In answer to the question about the special provisions for the hospital, I just saw the amended bill this morning, and I know I saw somewhere in here that where the hospital is the petitioner, that there would be an increased review by the court. that they would be subject to more frequent review of the guardianship orders. I just can't find it in here. So I think that there is something in there that deals with the issue of when a hospital or a nursing facility is a petitioner for a guardianship.
Okay, Senator Morsi.
Thank you. Ms. Wood, the Bridget Balch of the Richmond Times-Dispatch did a 3-part series called Unguarded.
Right.
It was a 10,000-word expose delineating what I thought was what this bill was trying to get at. And what it did is allowed this court in Richmond was appointing one individual, same attorney, to represent this individual, appointed them as guardian, even though they had family members, put the person out of the hospital into a Tier C, receive a home, and then as soon as he got in that home, was immediately relieved of his guardianship duties, and he did scores and scores of them.
That's correct.
You said that I read somewhere or I heard somewhere, that's what I want to be corrected. Does this bill do that?
Mr. Chairman, Senator Morsi, I believe the legislature enacted some controls in response to that story last year. And we don't have any reason to think that the enactment of that legislation last year has been ineffective.
Okay. Okay. All right. Any other questions?
Mr. Chair.
Yes, Senator Peterson.
Thank you, Mr. Chair. Here's kind of the issue. I'm trying to read this. It's 17 pages, and this is a fairly comprehensive rewrite of the statute. We don't get a hard copy anymore, apparently, which frankly is a little bit frustrating.
You should have a hard copy, Mr. Chair, on your desk, as well as passed out before the start of the committee. Yeah.
It was passed out a few minutes ago.
And Mr. Chairman, really briefly to Senator Morsi's question, the bill lays out a process. If the primary guardianship employs another individual for care, the primary person appointed still has to make at least 2 of the 90-day required visits themselves to document. It also requires the person employed by the guardian, if that condition exists, to also take the training. So there's a line of responsibility and training that follows through back to the appointed guardian in this bill.
Okay. Any other questions of the patron? All right, speakers. Another speaker. Your name, please.
Good morning, Chair and members of the committee. Emily Hardy with Virginia Poverty Law Center. We support implementation of the JLARC provisions which protect the rights of disabled adults. And specifically, we wanted to thank the Senator for bringing JLARC Recommendation 1, which is to put in place provisions that need to be done in the initial hearing with the GAL. And that starts on line 104. And what that does is requires a GAL to explain to a judge when they're not recommending counsel, when they're not doing a least restrictive alternative, and when they're not doing a limited guardianship. And what the point of that is to have the GAL have to explain to the judge can make that determination. Previously, they had to put the recommendation, but not the explanation. And additionally, this section requires that where a GAL has a request for counsel from the disabled adult, they have to give that information to the court. So we just want to thank the Senator for bringing these provisions that are in the initial hearing to make sure that the court case itself is doing its best to protect that person's rights.
Senator Norman, do you have a question?
No comments.
Okay, a comment, okay.
Thank you, Mr. Chairman. I see that Hal Greer and JLARC are here, but I just want to share with the committee that JLARC put an enormous amount of energy and effort into comprehensively reviewing this statute and articulated quite a number of suggestions, most of which have been incorporated in Senator McPike's bill, and I strongly support it.
Okay. Any other speaker?
Mr. Chairman, we do have one speaker online who would like to speak.
Okay, go ahead.
Erica Woods, please unmute and begin your testimony. Erica Wood, would you please unmute and begin your testimony?
Yeah, yes. Good morning. My name is Erica Wood. While I'm not speaking on behalf of any organization, I am a member of both the Virginia Public Guardian and Conservator Advisory Board and the Virginia Supreme Court Wings Working Interdisciplinary Network of Guardianship Stakeholders. And I'm retired now, but did work for many years for the American Bar Association where I focus most of my time on guardianship and related issues. In response to the question that was raised, I want to say that this bill puts in place review hearings, periodic review hearings, which can, under certain circumstances, be waived. But if the petitioner was a hospital or healthcare institution, those review hearings can't be waived. In addition, the bill would strengthen guardianship monitoring in a whole number of ways, providing for selected oversight visits, creating a complaint system, requiring, as I said, the review hearings to determine if a court order is still necessary or if it needs to be changed, and making the guardian report more informative. So it tightens up in all of those ways. This bill would really modernize the adult guardianship system around the themes of person-centered service and accountability, and I fully support it. Thank you.
Okay. Any other speaker? Okay. Is there a motion? Been moved. Yeah, moved that the substitute be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, vote no.
Senator Obenshain, how do you vote?
Senator Obenshain votes aye.
Ayes 15, no 0.
Thank you, Mr. Chairman.
What? Which is it? I think Senator Reeves is here. Yeah.
Thank you, Mr. Chairman.
Okay, Senator Reeves, Senate Bill 228, acquisition of military property by law enforcement agencies.
328, Mr. Chairman.
Yeah, 328, Senator Reeves.
Mr. Chairman,
No, you got the three, another one too.
I have 327 and 328.
Okay,
Mr. Chairman.
327,
You want-
arrest and summons quotas.
You want to take that one up first?
That'd be fine, either way.
All right, Mr. Chairman, this came at the request of the Police Benevolent Association. And what we found through some investigation is that there were some agencies within the Commonwealth that were using an informal quota system to issue summonses. And before I get to the bill, I have 3 amendments that bring peace in the valley, and I'd like to make those if I could, Mr.
Okay.
Chairman.
What are the amendments?
On lines 30, all the way to the end, and it says, as A, we strike out A and put in the sole. On lines 39, we strike out.
Line 30 under B. Read the whole thing.
Yes, sir.
A sheriff should not use, go ahead.
Issued by a deputy as the sole criteria. Then if you go to lines 39, we would strike out A after as and insert the sole criteria.
What line again?
39, Mr. Chairman.
Okay, 39. So,
As the sole. And then again on line 47. So you're covering state police, sheriffs, and police, regular police. So that would be line 47. After as, it says A criterion, we would put the sole criterion.
so is there a motion to adopt the amendments? All in favor of the amendment say aye. Aye, all opposed no. So making it the sole means you can do it, but you can't be the sole one.
Correct.
You can have a quota, but you can't have it.
Well,
Go ahead.
the challenge, Mr. Chairman, is there are some agencies, such as the state police, that their primary duties and responsibilities are to enforce the 46.2 code section on the highways and byways of the Commonwealth. And I'm going to let Mr. Sean McGowan and one of their representatives speak to that if you'd like to hear from them, Mr. Chairman.
I have a question. First of all, Senator Sasslaw has a question.
Yes, sir.
Used to hear about, these all the time, many years ago, but I thought that, that was pretty much something that been done away with. You're saying it still exists?
Mr. Chairman, Senator Sasslaw, I will say there are individual supervisors and maybe unbeknownst to maybe some of the higher authorities, their bosses, that some of these things are happening, and we just want to put an end to it.
Go ahead.
Mr. Chairman, members of the committee, I'm Sean McGowan. I represent the Virginia Police Benevolent Association. We have 8,000 law enforcement professionals in the state of Virginia, and that includes 800 state troopers who are in our state trooper chapter. Back in 2008, I was a police officer in Alexandria, and I was a motor unit, and in 2008, it was expected that I'd write 100 tickets a month. Last summer, News Channel 8 and Alley Racket with the Times Dispatch both did articles that revealed that the state police some commanders were holding troopers to certain particular numbers for tickets and had a quota in place. Our organization and our troopers feel that this is an antiquated system. It's ineffective in employee evaluation. We think that law enforcement needs to evolve. This is a reform bill, and we want to help move it forward. And we think this is the start of moving in the right direction of reforming how law enforcement officers are evaluated by their administration.
Have you heard the term, a ticket a day keeps a sergeant away?
Absolutely.
You heard that?
Yeah, well, when citizen would say, are you just trying to get your quota? And for years, we'd deny it because it was all unofficial, but we rely on to them because we did have a quota. We were expected to write those tickets. And I rode a Harley Davidson when I was in Alexandria. If I didn't write those tickets, I might not be riding that Harley Davidson, and I really wanted to keep riding it.
Okay, thank you.
Yes, sir.
Any questions of the speaker? All right, thank you. Next speaker.
Morning, Mr. Chairman and committee. My name is Daniel Gerasimowicz. I'm also with the Virginia PBA. I'm the chapter president of our state police chapter, which we have over 800 troopers in our state police chapter. These members brought their concerns to us about the ticket requirements or quotas and wanted to see something done about it. They believe that we have the great authority to warn, summons, and arrest, and we should have that discretion and not have an individual telling us how many tickets we should write. So we do support this bill wholeheartedly.
Okay, any other questions of the speaker? Okay, any other speakers? Here's another one coming up.
Mr. Chair and Committee, I'm Travis Bird, Commonwealth Attorney of Spotsylvania County, speaking on behalf of Virginia Association of Commonwealth Attorneys. We support this bill.
Okay, good. Thank you. Any other speakers?
Mr. Chairman, there are 2 speakers online.
Okay, online.
Rahman Fatahi, please unmute and begin your testimony. Norman Eichen, you will be next.
Good morning, everybody. This is Ramin Fatahi, Commonwealth's attorney for the city of Norfolk, and I'm here to speak on my own behalf and also on behalf of the Commonwealth's attorneys of Albemarle County, Fairfax County, Arlington County, and all of us also for the reasons stated support this bill. We ask that tickets be written when they're needed, not because the police require them. Thank you.
Senators Normation again. I was a longtime Alexandria resident for 12 years. I actually knew 2 Alexandria police officers who confidentially told me that this was exactly the case. They had to write so many. They were annoyed about it. There was even talk, and I can't confirm this, but I was told it by one of them, of a contest, at least one, where you had to write so many and you got something as a result of it off the books. So certainly I'm glad to hear that there's a little bit of police reform going on in there. Thank you very much.
Okay. Any other speakers?
Not at this time, Mr. Chair.
Sorry?
Not at this time, Mr.
Okay.
Chair.
Anybody want to speak against the bill? Is there a motion?
Mr. Chairman, I have a question.
Yeah, Senator Shorville.
Thanks. So, I think the whole idea of quotas is anathema to just about everyone. But I can also tell you that in looking at the data in Northern Virginia, the number of summons being written is off by about 70% in some of the counties up there compared to where it was at its high point. I want to say maybe 11 or 12, especially in like the last, 2 or 3 years. I mean, it's just fallen off a cliff. And, and I've talked to a lot of officers about it, and, they joke about how they're doing parking lot security now is what they call it. They sit around, they wait in the parking lot until they get a call, and then they go and respond to the call instead of being out proactively policing. And so I'm not sure that's actually an official policy of the department, but we're the department to try to ask officers to be more
proactive policing?
Proactive, right. I mean, how would they evaluate that without measuring it by the number of tickets being written? I mean, how do you evaluate whether somebody's actually out fulfilling the mission of the department and has asked them to fulfill out just, looking for violations as opposed, if they're not going to look at the number of tickets they've written. That's, and by the way, because remember, we've also passed a bunch of other statutes recently, like this employee retaliation statute and others that create a cause of action that an officer could bring if, the department retaliates them or against them or something for violating a policy that we've codified, So like, I'm just trying to figure out how you would implement this without causing problems.
Mr. Chairman, Senator Servo, here's what I would tell you. By adding the language of the sole criteria, that still allows them to look at not just summonses, but building checks. When you do your nightly building checks, as a police officer, we used to have a beat area, and we'd make sure that there were certain, like in Rumsco Plaza, I remember making sure the shooting place there was always checked because they had several break-ins, right? So we do those sort of things. There's a gamut of issues that you deal with as a law enforcement officer in the middle of a shift. Everything from an accident to DUI enforcement, if you have one of those checkpoints, to all these things. But what we found was some folks were judging officers strictly on the amount of summonses they write. And that's what we're trying to get away from. So I think the non-productivity of some of the officers up north is not due to a quota system, but more overall of the atmosphere that we see in the nation from, we've kind of been going through where, quite frankly, cops thought there was a war on cops, and they were like, hey, wait a minute. Every confrontation I have with a citizen is going to be maybe not a positive one, so maybe I shouldn't go out and do it. So I think that's more of a morale issue separate of this quota system.
Okay, are there additional questions? Are there, and have we already heard from the public on this bill?
Yes, sir.
Okay, is there a motion? Got a motion and a second. Are there other motions, or is there further discussion? If not, vote aye if you're for the bill.
Senator Obenshain, how do you vote?
Senator Obenshain votes aye.
Ayes 15, no 0.
Okay, Senator Reeves, your bill's reported. You've got another bill.
Yes, sir. I have Senate Bill 328 that Senator Bell gave me. This is a cleanup to Delegate Helmer's bill on acquisition of military property, and there was a causal effect of the bill that wouldn't allow our law enforcement officers the ability to use their shotguns. And so I have 3 amendments at the request of the Fairfax County Attorney, Mr. Hio, who is here to also speak to the bill. But if we look on lines 21, right before ammunition of 50 caliber, we say rifle ammunition. Put in the word rifle. On line 55, near the end where it says ammunition of, we put in rifle. And then again on lines 95, it goes through and says rifles of 50 caliber or higher, and then it goes again with the enunciation of rifle ammunition.
Do you understand the amendments? Joe, is there a motion on that? Second. All in favor of those amendments, which just clarify that it's rifle ammunition we're talking about. All in favor of the amendments, say aye. Aye. Any opposed? Okay, we've made the amendments.
Well, Mr. Chairman, the bill simply would allow them the opportunity to purchase shotguns, which is a necessary item when you're a police officer, and it's pretty much in every police car that's out there.
Does anybody have any questions of Senator Reeves? Okay, you've got some people who want to speak.
Just the Mr. O, the county attorney for Fairfax.
Yeah. Mr. Chairman, members of the committee, I'm actually the Deputy Legislative Director for Fairfax County. We thank the patron for this amendment. It simply aligns the language to the Appropriations Act passed by the 2021 General Assembly to address the unintended consequence of preventing local law enforcement from procuring 12-gauge shotguns and the associated ammunition. So we ask that you support the amendment.
Of course, with you don't talk about a caliber when you're talking about a shotgun, are you?
Well, Mr. Chairman, standard is a 12 gauge.
You're talking about, if you're talking about a shotgun, you're using gauge as your measurement.
Correct.
You're talking about a rifle.
It's
or
ammunition.
A handgun, you're talking about caliber.
Correct. Right on.
So it's clear the way it's written, but you're making it more clear.
Yes, sir.
Okay. Does everybody understand it? Are there other people that need to speak to this bill?
Did you believe, Mr. Chair?
Nobody virtually?
There is one.
One? Okay. Let's hear from them.
Elizabeth Hobbs, please unmute and begin your testimony.
Good morning, Mr. Chairman, members of the committee. I'm Elizabeth Hobbs, representing the Virginia Sheriff's Association. We are in support of this bill for all of the aforementioned reasons.
Thank you very much. Are there other people that need to speak?
Ms. Chair, just a clarifying question.
Senator McLeod.
I want to be sure I understood. This is current law in the budget, and you're just making this change in the code. Is that correct?
Yes, ma'am.
Thank you.
Mr. Chairman, I have a question.
Senator Serville.
Senator, I appreciate the clarification that's sought here, and 'cause I don't think we intended to prohibit anybody from buying a shotgun, as I think the chairman just indicated, but do we have your assurance that should this bill go to the other side, it ain't gonna come back with a bunch of amendments, undoing a bunch of stuff we did in the 21 special session?
Mr. Chairman, Senator Servo, I don't know what's going to happen on the other side.
Well, do we have your assurance that
certainly
if
can kill
anybody-
it if it comes back and it has amendments that I'm not favorable to. I'm going to ask for no amendments.
I got it, but do we have your assurance that you will oppose any amendments that try to broaden this beyond the scope of what you're trying to accomplish? Should the governor or the other side try to monkey with it?
Mr. Chairman, I'm going to carry the bill to the best of my ability to keep it whole. If the House decides to take it, I'm not, you all will make that decision. There might be a way to clean it up even better. I don't know.
Are there further questions? Is there a motion on the bill? Is there a second? Second. Okay, motion and a second. Are there further motions or further discussion? If not, open the roll vote. Yay if you're for the bill.
Senator Obenshain, how do you vote?
Senator Obenshain votes aye.
Ayes 14, no 0, abstentions 1.
Thank you.
Okay, thank you, Senator Reeves. Okay, the next, we've said, are there other non-patrons in the audience? There aren't. So the next bill, I guess, is Senator Peake, 174.
Mr. Chair, I'm going to ask that 174 go by for the
Okay.
day.
Okay, well then,
That I've got some work to do on that.
okay. Senate Bill 174 is going by for the day. Senator Sherville's got a quick bill, he says. That's 1392.
Thank you, Mr. Chairman. Can I present it from here?
You sure can.
Thank you, Mr. Chairman. So Senate Bill 392 is a small clarification that's brought to my attention by one of my local circuit court judges in situations where the court is asked to appoint an expert witness, ex parte, in an indigent case. And she had an expert that she appointed who wanted to have a copy of the appointment order for his file. And she read the statute, was concerned that the statute prohibited her from giving the sealed order to the actual expert. And so this bill just makes it clear that she can give the order to the appointed expert.
Does everybody understand the bill? It seems fairly simple. Is there anybody in the audience, either here or virtually, who needs to speak to this bill?
Not nearly.
Nobody? Okay. Is there a motion? Is there a second?
Second.
Motion's been made and seconded. Are there further motions or further discussion? If not, please open the roll. Vote aye if you're for the bill.
Senator Obenshain, how do you vote?
Senator Obenshain votes aye.
Ayes 15, no 0.
Okay. Thank you, Senator Serville's quick bill got passed. Senator Boysko's got a quick bill, she says. McClellan, I apologize. I picked the wrong member of the Jennifer caucus.
First, Mr. Chair, I would ask that Senate Bill 474 go by for the week.
Okay.
And
Senate
then,
Bill 474 is by for the week, without
And-
objection.
and then I have Senate Bill 470, which authorizes the conveyance of an easement from the Science Museum to the Children's Museum. When we were there last year, you may have noticed the Science Museum was building a parking garage to replace the surface lots and a green space. And in order for the Children's Museum to be able to park in that parking deck in perpetuity and to make use of the green space, Office of the Attorney General said that that easement could only be granted by legislation and not by the Science Museum itself.
Okay, does anybody have any questions of Senator McClellan? Are there those in the audience who would like to speak to the bill, or those in the virtual audience? There's nobody. Okay.
I move to
Is
report.
there, okay, there's a motion and a second to report the bill. Are there further motions? Is there further discussion? If not, vote aye if you're for the bill.
Senator Obenshain, how do you vote?
Senator Rubenstein votes aye.
Okay.
Ayes 15, no 0.
The bill is reported. Okay. You have a quick bill, Senator Stewart. It's 404. Senators, turn your attention to Senator Stewart.
Thank you, Mr. Chairman, members of the committee. Senate Bill 404 very simply allows, take this thing off, allows the person serving a search warrant to give it to at least one of the occupants if the owner or the person to be searched is not on premises. This is just a cleanup, and actually it comes as a request from at least one jurisdiction to clear this up, because sometimes you can't find the occupant of the place to be searched. We haven't discussed.
At the present,
Yeah, but we haven't
present law, you've got to provide a copy to the owner or the occupant. Is that right?
The owner or the person to be searched.
Or, Mr. Chair, it specifies any occupants, and I believe some jurisdictions are taking any to mean all occupants, which at least one would provide, you just give it to one, you don't have to search out for all the occupants. That's the clarification.
Right.
Mr. Chair.
Mr. Chair.
Senator Boysko.
Mr. Chair, I have a question. What if the occupant is a child or a teenager or other minor or a completely unaffiliated person with, when the police get to the residence?
Otherwise a stranger?
No, a child.
Child.
It doesn't say any here, I mean, the way I'm looking at this, it appears that if I am a 12-year-old staying at home babysitting my little sister, that I could be served the warrant as well, which I would like some clarification on.
I hadn't
Just-
considered that.
I think that would be a problem. I wouldn't be able to support this bill if that were the case.
Mr. Chair, we could just have adult. Yeah, at least one, insert adult occupant.
Isn't, Mr. Chair?
Senator Peterson.
In the service section of the code, doesn't it say you have to be, anyone 16 or older can receive service under 8.01? Now, that's civil service, not a affidavit. What's that?
I don't think it.
I know that, but I'm just saying that would be a comparison.
I think adult occupant fixes it.
All right, fine.
Take the bill by.
Excuse me?
Did you say take the bill by?
No, I think adult occupant fixes it, so if we
Okay.
just add adult before occupant, and I would move that amendment, unless Mr.
Second.
Benjamin.
Also, Mr. Chairman, Senator Stewart, on line 98, where it provides if the place is unoccupied, I think you should insert is unoccupied by adults. By an adult. So that if the police arrive, there's a child there, then they merely need to leave the search warrant in a conspicuous place.
So, Mr. Chairman, I would move
Both
that.
of those in a block?
Yes.
Okay, and your second applies to that? Okay, all in favor of, does everybody understand the amendments? All in favor, say aye.
Aye.
Okay, the bill's amended to require service on adult occupants.
Move to report as amended.
Okay, got a motion and a second. Are there further motions or further discussion? If not, vote aye if you're in favor of the bill.
Senator Obenshain, how do you vote?
Senator Obenshain votes aye.
Ayes 15, no 0.
Your comment addressed one of my questions. If the building is unoccupied
Okay.
entirely, it's that premises are searched and a search.
The bill's reported. Okay, I think we're down to bills that I've got or that Senator Edwards has, and I don't know whether he asked, Senate Bill 302, he asked that bill go by for the week, or go by for the day. And without objection, that's one of my bills. I would ask that it go by for the day. And on my bill, Senate Bill 295, apparently there's a dispute between the Committee on District Courts and the district court judge that asked me to put this bill in. So I'm going to ask for a few more days to try to figure out whether that dispute can be brought into line. So I'd ask that that bill go by for the day. The other one that I've got is 296. And 296 is very simple. It simply codifies established law, which is necessary to do because we repealed the capital sentencing statute that what provided for this. So it expands the law, also expands the law on what constitutes mitigation to allow adolescent brain development, low risk of older offenders, convictions, sentences imposed against co-defendants, and effective incarceration on the defendant and family. This just discusses what's relevant evidence in the sentencing phase of a trial. Senator Peake.
And I understand the first part of the bill, the things you are adding in, the brain development and those would be newly codified factors that can be brought in,
Right.
correct?
Yeah, that is new. There's no question about that. The mitigation is not new.
Yeah.
The definition of some of the mitigating factors that can be considered, that is new.
Mr. Chair?
Senator Boysko.
I have a somewhat similar bill, and I haven't compared the two. It deals with people with intellectual disabilities and giving the court additional opportunities to take that into consideration. I don't know if we should look at the two of them together.
If you want to take this by for a day or two and just try to compare the bills, that's fine with me.
Okay.
Okay, that bill will go
move
by
that.
for the day without
Thank you.
objection. Well, Senator Edwards left his stuff, his files here, and he has 3 bills, and I would suggest that we just pause for a few minutes and wait for Senator Edwards.
Where is it? She's asked that her bill go by for the day, Mr. Chair, so I recommend that we take a brief recess.
Okay.
I gotta go to local government then.
Mr. Chair, I was going to say, I believe Senator Edwards is carrying Senate Bills 423 and 424 for the Sentencing Commission.
Well, yes, he's got those. Can you handle that?
I know Meredith is here from the Sentencing Commission, so I believe she can present those bills, or I can present those bills, either, whatever the chair's preference is.
That, either is fine with me. If you can handle those bills, let's get them taken care of then. 423 is the first one. I would ask you to turn your attention to the podium.
Yes, sir. Good morning, Mr. Chairman and members of the committee. I am Meredith Farrar Owens. I'm the director of the Virginia Criminal Sentencing Commission, and it's my pleasure to be here this morning to speak to Senate Bill 423. One of the goals of Virginia's sentencing guidelines has always been to reduce unwarranted sentencing disparity and increase consistency and predictability in sentencing. Unlike most states with sentencing guidelines, Virginia's guidelines are based on analysis of historical sentencing data. In fact, 17.1-803 requires the commission to take into account historical sentencing practices. In essence, the guidelines are designed to provide judges with a benchmark of the typical or average case outcome given the defendant's current offenses and prior record. But there is one exception to the historical basis of Virginia's guidelines. Per 17.1-805, the guidelines must include enhancements to increase sentence recommendations for defendants who have been convicted of violent felony offenses as defined in that section. That section also specifies the amount of the enhancements. The section specifies enhancements of 100, 125, 300, or 500%, depending on the nature of the defendant's current and prior convictions for violent felonies. These percent enhancements are not based on empirical analysis of the data, and they have been in the code since 1995. Recently, the Commission approved a full-scale reanalysis of all Virginia guidelines. The approach will be holistic and comprehensive. The goal is to re-benchmark the guidelines so that they accurately reflect current sentencing practices to every extent possible.
Are there any questions from the committee? Do we understand this bill? Senator Morsi.
The guideline, the high end of the guideline would not be increased. This just deals with the midpoint, allowing for an increase of the midpoint. Is that correct?
This bill would give the Commission clarify the authorization that the Commission can set the size of these midpoint enhancements based on actual sentencing data and not the exact amounts that are currently specified in the code that have been there since 1995. This just clarifies the Commission's authority to base those on an actual analysis of the data.
Mr. Chair.
Senator Morsi.
Thank you, and thank you for the presentation, but that wasn't my question. It seems to be that it may increase the midpoint of the recommended sentencing range. My question is, does this have anything to do with the high end of the guideline?
So as you know, the guidelines are presented to the judge in the form of a range with a low end, a midpoint, and a high. So in this case, we would adjust the range if necessary based on whatever our upcoming full-scale reanalysis. So what I expect in this situation, what we have seen in the data is that while judges comply with the sentencing guidelines at a very high rate overall, this is an area, these midpoint enhancement cases, this is an area where judges do tend to depart more often, and they tend to depart below the guidelines in these cases. So the Commission's recently approved study that we're going to revamp the guidelines certainly would include a detailed examination of these cases. So what I expect, Mr. Chairman, Senator Morrissey, is that in some of these situations, in fact, probably most of them, the range will actually come down somewhat from this range that's specified in the code at the moment based on these 100, 300, and 500% enhancements.
Mr. Chair.
Senator Morsi.
I'd ask the council, I see where it talks on lines 13 may increase the midpoint. On lines 16 and 17 may increase the midpoint. On line 20, sentencing guideline midpoints. My question again is, does this have anything to do with increasing the high end of the guideline? For example, if the guideline range was 1 to 3 years, does this bill have anything to do with increasing the 3-year limit?
Mr. Chair, the bill does not speak of increasing the range of the guidelines, just the midpoint of the guidelines.
Okay, all right, thank you.
Are there further questions?
Mr. Chairman, if I may, just in closing, certainly any recommendations adopted by the Commission to revise the sentencing guidelines would only come into effect through the process that's already specified in the code in 17.1-806, which gives the General Assembly an opportunity to review the Commission's recommendations for any changes to the guidelines.
Okay. Are there those in the public that need to speak to this bill?
Mr. Chairman, at this time, there's no hands raised.
There's nobody?
There's-
Okay. Is there anybody in the audience? Is there a motion on the bill? This is a Sentencing Commission bill. Is there a motion on the bill? Motion and a second. Are there further motions? Further discussion? If not, vote yes if you're in favor of the bill.
Senator Obenshain, how do you vote?
Senator Obenshain votes aye.
Ayes 15, no 0.
Okay, the bill's reported. SB 424 is also a Sentencing Commission bill.
Yes, sir, Mr. Chairman. Senate Bill 424 quite simply replaces similar language that has been in the Appropriations Act since 2010 and codifies current practice in regards to the probation violation guidelines. The General Assembly first directed the Commission back in 2003 to develop guidelines for probation violators returned to court for technical violations of supervision, and as required, we did look at historical sanctioning practices in revocation cases to develop those guidelines. The study did reveal wide variation in the handling of probation revocations across the Commonwealth. In its 2003 annual report, the Commission recommended that the probation violation guidelines be implemented statewide. The General Assembly agreed or accepted that recommendation, and statewide use began in 2004. Since 2010, the Appropriation Act has included language to specify that a sentencing revocation report and for technical violations, the probation violation guidelines must be submitted and reviewed to the court for any violation hearing for a person on probation for a felony. Recently, in 2020, the Commission completed a large-scale multi-year study to update the probation violation guidelines, and based on the results of the study, the Commission recommended numerous revisions to the guidelines, including an expansion to cover for the first time violations arising out of new felony and new misdemeanor convictions. This expansion was supported by circuit judges when asked through a survey. The recommendations were included in the Commission's 2020 annual report and were accepted by the General Assembly last year, and the changes went into effect July 1st, 2021. Mr. Chairman and members of the committee, Senate Bill 424 codifies the probation violation guidelines in the same manner as the guidelines for felony offenses are currently, and it ensures that the statutory language accurately reflects the current use of the probation violation guidelines as approved by the Commission in 2020 and accepted by the General Assembly in 2021.
Mr. Chair.
Senator Morrissey.
I beg your pardon. Tell me your last name again, please.
I'm sorry, Meredith Farrar Owens, Director of the Sentencing Commission.
All right, thank you. Right now, the circuit court judges are getting a written guideline for a probation violation, correct?
Mr. Chairman, Senator Morrissey, yes.
Follow-up question.
Senator
You
Morrissey.
want to codify that, is that correct?
Yes, sir.
Final question. Just like in a sentencing proceeding where if the judge goes over the guideline and perhaps under, there has to be an articulated reason for that. Is that the same for a probation violation?
Mr. Chairman, Senator Morrissey, yes. The language in this bill would ensure that judges are required to file a reason for departure.
Thank you, Mr. Chair.
Is it fair to say that this is kind of a response to legislation that passed last year? This limited punishment for certain technical violations, and as a result, there's been a vast inconsistency in the way courts have treated that statute?
Mr. Chairman, I will say that the Commission's recommendations for changes were based on the study it completed in 2020.
Okay.
I will say that the guidelines were further adjusted due to legislation adopted by the General Assembly last year. The probation violation guidelines were adjusted so that they will not recommend any sentence longer than what is permitted under the new law.
Mr. Chair.
Senator Morrissey.
This issue has been percolating for several years. It did come up last year, and I don't believe that any legislation last year was the genesis for this bill, but it certainly added to it. But for a very long time on a probation violation, the disparity in sentences handed down by judges did vary dramatically. I'm grateful to see that we're now codifying that, what we hope the circuit court judges are now doing.
And Senator Morrissey, I agree with you. I'm just thinking, I know that one circuit court judge this past year said that what we did was unconstitutional last year. And if we put this in code, we'll clarify that issue for that circuit court judge. We'll give him more instruction on what he can and can't do.
Mr. Chairman, if I may, this legislation really is separate and apart from the issue, any issues that may be arising out of the legislation you all adopted last year specific to technical violations. These guidelines are discretionary for judges. They simply provide that benchmark of what typically happens in these revocation cases and giving them some idea of what the going rate is, if you will, for certain probation violations. And then, of course, they can take into consideration the details of the case and the individual before them. But this is really a separate issue than any issues that might be arising from legislation from last year.
Okay, are there further questions of this witness? Are there people in the public, either in this audience or in the virtual world, who need to speak to this bill?
Mr. Chairman, there's one hand raised.
Okay.
Emmanuel Harris, would you unmute and please begin your testimony? Emmanuel Harris, would you please unmute and begin your testimony?
Yes, thank you. I'm Emmanuel Harris. I'm with the Baptist Ministers Conference of Richmond and vicinity, and I'm also with the Black Coalition to Change. We support this bill, and we think that it will help to address the sentencing inequities. That's all I have to say. Thank you.
Thank you very much. Okay, is there a motion on the bill? Motion and a second. Are there further motions or discussion? If not, vote yea if you are for the bill.
Senator Obenshain, how do you vote?
Sir Obenshain votes aye.
Ayes 15, no 0.
Okay, the bill's reported. I've
Thank
got
you,
one
Mr.
more
Chairman.
bill for Senator Edwards, but if I read this correctly, Senate Bill 396, we don't have a state agency to speak to this. We don't have anybody.
Mr. Chair, I have a note that Senator wanted Eric Reynolds, from the Office of the Children Ombudsman, to present on this bill. So if that's acceptable with the chair.
Okay, that's fine. Mr. Reynolds?
Mr. Chairman, before Mr. Reynolds starts his presentation, Senator Edwards does have a substitute that's been posted online that he wanted the committee to consider.
Has a substitute online.
I believe Charles has copies.
You should have it in front of you, Mr. Chair.
It's being distributed right now. Is there a motion on the substitute? A motion and a second to adopt the substitute. All in favor, say aye.
Thank you very much.
Opposed?
Police.
Okay, the substitute's
sorry.
before you. It's a pretty thick document, 21 pages. We'll try to absorb it while Mr. Reynolds presents.
Good morning, Mr. Chair, and members of the committee. Eric Reynolds, Director of the Office of the Children's Ombudsman. This bill addresses an issue that Senator Edwards had brought to my attention. Also an issue that I have seen myself in some of the cases that my office has reviewed, and that is related to the decisions made by local departments of social services regarding the placements of children who are in foster care and the role of the courts in reviewing the status of those children. Number one, it clarifies existing law regarding the court's authority to review the status of these children. Currently, you'll see on lines 47 to 48, 71 to 72, and other lines that there's language that requires, or that gives the local agency or board that has custody of these children final authority to determine the appropriate placement for the child. Now, there's been some confusion or some interpretation of that final authority language prevents the court from reviewing such placement decisions. However, we do have case law by the Court of Appeals that says that as the final authority is against other parties in the case, parents, relatives, FAP teams, GALs, but does not affect the authority of the court to review the status of the child under 16.1-281. So the first set of amendments dealing with that final authority language addresses and confirms with the Court of Appeals case law regarding the authority of the court to review and qualifies the agency's final authority by as not limiting the court's existing authority. Number two, the bill ensures that information regarding the child's placement is provided in the foster care plan that's submitted by the agencies to the courts and to the other parties, so that there's this special attention being made to the decisions, what information the agency used to make the placement decisions is being put in writing in the foster care plan so that it can be properly reviewed by the court and properly addressed by parties if they want to challenge any of those decisions. So that's the second part of the bill. The third part deals a list of factors, best interest factors that the court should consider when they are reviewing the placement decisions of the agencies and also ordering custody at the end of the case at the permanency planning hearing when they do transfer custody to a family, a relative or such. There's factors that the court can consider in the best interest, in determining the best interest
Can you
of the
just tell
children.
us what the differences are between the substitute and the bill as filed? I mean,
Some technical language, we were working with OES and with other parties to try to get this to be implemented by the courts.
one thing when I read through this last night was it just seems like the best interests is enumerated in this bill are different from the best interests that are enumerated in the code section that deals with visitation and support and custody and that sort of thing. I mean,
Mr. Chair, yeah, that has been an issue here in Virginia because we do have the best interest factors in Title 20, which addresses private custody cases as between family members. But we've never had any factors that address best interest when it comes in this context of children in foster care, when you're not just dealing with relatives, but you may be, or family members, immediate family members, but you may be dealing with relatives as well, or adoptive placements.
and you've still got the language on line 540 that demonstrates that the other language is not an exclusive list of what the best factors,
Correct.
best interests are. Okay, are there questions of Mr. Reynolds? Are there those in the public who would like to speak to this bill? Valerie.
Thank you, Mr. Chair. Valerie LaRue from Virginia Poverty Law Center. And we support this bill. I think that Senator Edwards' experience in court reflects experience in court that I've had representing parents in these matters and also relatives. And that is whether the court is confused about what power they have to make these kinds of decisions when the language of the statutes currently says that the department has the final authority. This would still give the department the final authority to recommend the placement decisions to the court, but would allow the court to review it.
Valerie, that makes perfect sense to me. Are you all right with the list of best interests?
Yes, Mr. Chair. The court has to make these placement decisions in the best interest of the child, as
Right.
what you might expect. But the only best interests that we have that are codified are, as Mr. Reynolds said, the ones that are as between parents fighting over custody or making those kinds of determinations. But we don't give any guidance to the courts as to what kinds of things to consider when the child is in foster care. You know, when the court is trying to decide, yes, should the child be adopted? Should the child go to a relative? This just gives the court some things to consider. It's still completely in the court's discretion, and the court can still consider other factors, but it just gives some things to think about, basically.
Thank you very much.
They're not required. Thank you.
Thank you. Are there others? Are there people in the virtual world who need to speak?
Mr. Chairman, there is one hand raised.
Okay.
Sandra Harrison, would you please unmute and begin your testimony?
Good morning, Mr. Chairman, members of the Senate Judiciary Committee. My name is Sandra Harrison. I'm with the Office of the Executive Secretary at the Supreme Court of Virginia. The court doesn't have an official position on the bill yet, as it remains in our legislative review process. We do appreciate Senator Edwards and the proponents of the bill working with us, along with legislative services, to address initial concerns. I would be glad to respond to any questions. Thank you.
Okay, are there any questions of this witness? Thank you, Ms. Garrison. Okay, the bill's before the committee. Do you have? Move to report. Is this a bill that has to go to finance?
It is not, Mr. Chair.
Okay. Motion to report, is there a second?
Second.
Okay, are there further motions or further discussion? All in favor, vote yea.
Senator Obenshain, how do you vote?
Senator Obenshain votes aye.
Ayes 15, no 0.
Thank you, Mr. Chair.
Ayes 15, no 0. The bill's reported. I think that's the last bill. So we'll rise.
Chair, it is.
You have a question, Senator?
Mr. Chair, you have continued, passed by for the day, your bill, Senate 296. Is that correct?
296. I think all three of my bills went by for the day. And that bill went by because Senator Voisko said she had a similar bill and she wanted to compare them. I was trying to take care of that one.
One thing that I just would mention to Senator Boysko and you is I've looked over that legislation and it doesn't deal with a scenario where the judge does the sentencing. I think it's wonderful that we are codifying all of the things in lines 34 through 53 that can come in during the sentencing phase of a jury, with a jury sentence that I'm saying to both of you, we need to include a provision that it can also come in the sentencing phase where the judge alone does the sentencing. It adds many things like Senator McClellan's bill last year that allowed evidence of mental health illness to come in during the guilt and innocence, and it now clarifies that it can come in during the sentencing. But we need to make sure that this same cadre of evidence can come in during a judge imposed.
I agree with you. I mean, I think the purpose of the bill was that a lot of the mitigation language had gone out of the code when the capital punishment was repealed. I agree with you. We'll make the changes as
Do you want
necessary.
me to speak to both of you, or just?
Well, both of us is fine.
Okay, all right. 296. It's good.
Are we done? We're done. You mean I ran all that hard?
Senator, could you adjourn this, Mr. Chair?
Okay, John.
We're adjourned.